Good to have you. You had a panel discussion. For you, what are some of the major key takeaways from that?
See, my panel discussion was very interesting. It was on the hot topic of the IBC and what are the reasons for the lacunas and the delays in the IBC. And it was quite a fruitful discussion that we have, quite a few takeaways which we want to implement practically while going to the courts and the NCLTs to see if we can better the position than what it stands today.
We are talking a lot on the lines of how advanced technology is coming in, a lot of AI interventions. But with that, we know that there are huge possibilities of data breaches all across the sector. It's not just limited to the lawyers or some. But how do you look at it when we talk about AI coming into play? And we know that we need to be very, very compliant and very, very stringent on the lines of how client details remains confidential. How do you look at it?
So see, every technology as and when it comes in has always been a boon as well as a bane. It's how we tend to pick it up. Mobile phones, for a lot of people, they are a boon and it is a part of the booming economy, mobile phones and communications. But for a lot of people, it's also a bane. But we've lived through it and seen that as and when, wherever we go and we start imbibing more and more technology into our lives, the same question will keep coming up again. But as we develop and inculcate the technology, we sort of try to live with it, and all the problems that we foresee today sort of solve themselves out with time and with legislative intervention, obviously. I mean, we have legislature going into every question and framing laws for everything. But as and when it's inculcated to that level is when the intervention happens, and once the intervention happens, whether right or wrong, we tend to live with it.
Likewise, we are also discussing a lot on mediation, and some discussions also were on the point of mandatory mediations. How do you look at it, and in your point of view, how would this shape up in the next few years? What will be some of the major trends?
So mediation is actually not a new concept. We are talking about it today, but if you'll see the legislative history, mediation found its place in the CPC in 1908. Then we had a very important act which is known as the Arbitration and Conciliation Act of 1996. Now, for some odd reason in this particular act, we forget the word conciliation. But conciliation was very much a part of the 1996 Act, which has now been repealed for the new Mediation Act. So we've had mediation all along. Even the Commercial Courts Act has always had a provision for mandatory mediation. Now, having said this history of mediation, what I want to emphasize on is that slowly people in commercial disputes will start picking up the fact that it's not good to waste good money behind bad money. So please do not waste money on litigation and or arbitration, especially in a commercial dispute, when the matter can get resolved by mediation and negotiation. Once people start understanding this by saving money and on commercial parameters, mediation will actually pick up a lot, and it is one aspect to look out for in the future.
You mentioned about arbitrations being a very, not early in your words, but it is a little tougher way to go forward when we relatively compare it to mediation. And apparently, many arbitrations has ended up with a huge burden of legislation on court. In your view, how this can be dealt positively in some way?
So I think the 2015 amendment to the Arbitration Act has taken care of this problem, specifically the second part of the problem that you mentioned, that a lot of arbitrations going to courts and then the same rigor being followed. But so as per the 2015 amendment, section 34 has been amended to a certain extent. Now we exactly know on what parameters can we approach the court. If those parameters don't exist, then the courts are also very pragmatic in actually dismissing matters on the first day or in a very short span of time. So the wastage of time or the pendency in courts because of arbitrations has considerably reduced on that account.